We are here on a notice of change status. If I could, before stating the terms of any proposed order, I'd like to offer into evidence what's been marked for identification purposes as State's Exhibit A. It is a copy of correspondence between me and a caseworker from the Department of Family Protective Services regarding an investigation concerning the children in this case.
State's Exhibit A is admitted.
Thank you, Judge. I do not want to share it based on the sensitive nature of it. The court might want to review it before we proceed, as it will explain the proposed order and some of the testimony, or would you just like for me to proceed?
You may proceed, Mr. Tal.
Okay. It has been emailed to you directly if you'd like to look at it.
Yes, I got the email.
Okay, thank you, Judge.
Right.
May I proceed stating the proposed terms?
You may.
The order would name Mr. Crook as the managing conservator of the children and Ms. Nave as the possessory conservator, with Mr. Crook being the conservator with the exclusive right to designate the primary residence of the children within Dallas or any contiguous county. There is a finding that there has been a history or pattern of family violence on the part of Ms. Nave within 2 years, and a finding that her having access to the children would not endanger their physical or emotional welfare so long as her possession and access is supervised. And then the visitation would be from 11 a.m. to 1 p.m. on the first, third, and fifth Saturday of each month, with those periods of visitation to be supervised by Mr. Crook or an individual he designates at the McDonald's located on Preston Road in Dallas or any other mutually agreed upon location. Mr. Crook would be ordered to apply for or maintain the children on the government medical assistance program. Ms. Nave would be ordered to pay cash medical support of $50 per month beginning June 1st and guideline child support of $275 per month beginning June 1st.
275?
Yes, Judge.
And 50, correct?
Yes, Judge.
Okay, thank you.
The order contains a child support judgment against Mr. Crook after a possession credit is applied in the amount of $6,456.76. That is as of May 15th. That judgment would be payable at $60 per month beginning June 1st. There's also a medical support judgment against Mr. Crook after the same possession credit is applied in the amount of $2,141.19. And that judgment would be payable at $35 per month beginning June 1st. And that possession credit is for the time period from June 2024 through May of 2025. Court costs would be as billed to Ms. Nave. And there would be a finding of non-disclosure as it pertains to Mr. Crook's address and other identifying information. As the extent of the proposed order, if I may call the parties.
You may.
I'll call the father. Sir, would you please state your full name?
Antonius Crook.
And in June of 2024, there was an incident concerning Ms. Nave and the children, which prompted a CPS investigation to begin. Is that correct?
Yes.
Okay. And at that time, the children were removed from Ms. Nave's possession and placed with you. Is that correct?
Yes.
And they have been with you since that time. Is that correct?
Yes. Yes.
Now, part of the exhibit that was entered into evidence previously, is it your understanding that there was a finding on the part of the department that Ms. Nave was responsible for neglectful supervision of the children?
Yes.
And it's your understanding that the children, based on that finding, are to remain with you, correct?
Yes.
Are you asking that any visitation that Ms. Nave have be supervised as a result of those findings?
Yes.
And are you asking that you or someone that you designate be responsible for the supervision?
Yes.
Is there anyone in her family that you would be comfortable doing the supervision?
Her mom.
Her mom?
Yes.
Okay. What is her name? Do you know?
Like I just call her Miss McCoy.
Okay. Have you participated in services with the Department of Family Protective Services?
No, I know they came to my house and like pretty much like making sure everything is okay with the children.
That's what I mean. You are continuing to be
Yes.
engaged with them.
Yes. Yes.
Okay. To your knowledge, has Miss Nave engaged in any of those services?
No.
Due to the incident that was back in June of 2024, are you also asking that the court make a finding that there's been a pattern of family violence on the part of Miss Nave?
Yes.
And due to the fact that you're requesting the visitations occur at a neutral location, are you also asking that the court make a finding of non-disclosure so that your address and other
Yes.
identifying information are not included in today's order?
Yes. Yes.
You heard all of the terms that I stated to the court, correct?
Yes.
And you understand all of them?
Yes, sir.
And you believe the court entering that order as stated would be in the best interest of your children?
Yes.
I'll pass the witness, Judge.
You may call your next witness.
I'll call Ms. Nave. Ma'am, would you please state your full name?
Sydney Nave.
Did you hear the terms of the proposed order that I stated to the court?
Yes.
Do you understand those terms?
Yes.
And you are not in agreement with any of the terms of the order, is that correct?
No.
Okay. So you are asking that you remain the person that has the right to determine the primary residence of the children, and that Mr. Crook be ordered to continue paying child support. Is that correct?
Yes.
Okay. Is it true that the children have not been residing with you since the incident of June of 2024?
Yes.
Okay. Please tell the court why you believe it is in the children's best interest for you to remain their primary conservator.
I believe that the finding that I talked to you earlier was the first time I'm hearing about it. I've been calling for months to get information. Nobody has not talked to me. This is the first time that I even got anything from anybody. So, and I don't believe in their findings. They didn't do any investigation. I only talked to one person one time since the whole thing started. So I'm confused pretty much. And,
Okay.
and I don't even know what it's based off of.
So in June of 2024, the children were removed from your custody by CPS, correct?
Yes.
Okay. Have you made any attempt to have the children returned to you?
Yes. And I talked to only one person from, I think either the what is it, either the CPS or the DF, the
Same
other
thing.
one.
The same
Okay.
thing.
I only talked to one person one time. That's it. And I've been calling for months trying to get information, trying to get any type of documentation. And today is the first time I even got the documentation that you sent me.
The documentation that I sent you was entered into evidence earlier, and it includes a statement from the CPS investigator that you have not cooperated and participated in the services with them. You dispute that?
Yes, I do dispute that. I never talked to anyone, so I can't even defend myself. They don't even know my story.
This one conversation you had with them, so the incident occurred on June 12th. Was the conversation on that date or close to it?
No.
Okay, when did you actually speak to someone from CPS?
It was July. Hold on. I have it written down somewhere. It was in July. It was the first time I actually talked to somebody since the incident. And then even after that, I didn't talk to nobody else. And I was calling.
Were the children removed at that time when you had that conversation, or did it occur prior?
No, they were removed at the hospital.
Okay, and then you had a conversation with someone from CPS later. Okay.
Yes. And that was it.
Okay.
So they never did any investigation.
Okay. Is there anything else that you'd like to tell the judge?
Like I said, they didn't do any investigation. I've been in constant contact with the detective down in Houston, but that was about it. But nobody from CPS.
Have you filed anything with the court in an attempt to get your children returned?
No, because I was waiting on the ruling and paperwork from CPS. And I've been in constant contact with the father of my children since then. So I don't know.
I'll pass the witness, Judge.
Have you seen the children since June of last year?
I have.
Always supervised by their dad?
Yes.
Okay. And you didn't go to a CPS office and demand that somebody talk to you?
They said I couldn't come up there without an appointment. That's
Okay.
what they told me on the
Did you
phone.
go up there and make an appointment?
I had to do it over the phone.
Well, did you make appointments?
I tried, but they were saying because I didn't have my case number, I couldn't go up there because I didn't know who to talk to.
Okay, so when you were on the phone with them, did you ask them for your case number?
Yes, and they couldn't give it to me because they didn't. For some reason,
They can mail it to you, ma'am. They might not be able to give it to you over the phone.
they said they mailed it already, and I don't know where they mailed it to.
Then you
And they
should have asked them to remail it.
Yeah, we did, and I've been waiting for it in the mail, but nothing hasn't came yet.
Okay, well,
I gave them the
because
address.
of their findings and I don't know what efforts you made, but all I can say, if somebody took my kids, I'd bother them every day. And I'd be at their office, even if they told me I couldn't be at their office, because they'd have to tell me something. Okay. So I'm going to find Dad to be sole managing conservator, you to be possessory conservator, make a finding of family violence, supervised visitation from 11 a.m. to 1 p.m. on the first, third, and fifth Saturdays of each month. Mr. Talley, the only thing I didn't get is the location of the visitation.
It is a McDonald's at 17250 Preston Road in Dallas.
Okay. At the McDonald's at 17250 Preston Road in Dallas, Texas. That visitation will be supervised by Mr. Crook, by Miss Nave's mother, or any adult individual that Mr. Crook deems reliable. Dad will maintain government health insurance on the children. Mom will pay cash medical support of $50 each month, pay child support of $275 each month. There'll be a child support judgment after possession credits against Mr. Crook in the amount of $6,456.76. That judgment will be paid at $80 per month. There'll be a medical support judgment after possession credits of $2,141.19. That judgment will be paid at $35 per month. Court costs as billed. All start dates will be June 1st, 2025, and the non-disclosure is granted. Does anyone have any questions?
I
Yes,
do.
Mr. Crook.
So my last like on page 4 of my like the of my child support, it said I had a history of family violence, which I did not have at all.
Mm-hmm.
I never went to jail on the family violence at all, and I was trying to see if you can remove that off of the case.
I
Please.
can't remove it off of that order. That
Okay.
order is that order. And now we're going by this order.
Okay.
This order has family violence against Miss Nave. It does not report
Okay.
any
I
family violence
I just
against
wanted to
you.
make sure. Thank you.
Okay. Uh-huh. Any other questions?
What family violence is it because of the CPS case?
Yes, ma'am.
Okay, that's a history, but that's not a history though.
So it's not a history, but it's egregious enough for it to be a family violence finding. And I don't know who's in the room with you telling you what to say and what to ask, but if they're not an attorney, you should not be listening to them. Okay? Now that I've made my ruling, I'm not the last word on this. This is out of the 255th District Court. That is Judge Vonda Bailey. She might have a different opinion from mine. So you have 3 days to appeal, 30 days to file a motion for new trial. Now that I've given you that information, does anyone have any questions?
No, ma'am.
Ms. Nave, do
Okay.
you have any questions? All right,
No.
then thank you for appearing here today, and you're
Sorry,
free
Judge.
to go.
I do have one question regarding clarification on your ruling.
Okay.
I wanted to see if this was a miscommunication or if you were ordering something other than what was proposed on the payout on the child support judgment. 60 was proposed, but you ruled 80.
Oh, no, Mr. It was a miscommunication, Mr. Talley. I don't know why I thought I heard 80. Okay, so then that'll be $60 per month instead of $80 per month.
Thank you, Judge.
Thank you, Mr. Towle.
Thanks.
All right, if there are no further questions, then everyone is free to go.